Out of my courtroom. 5 words, nothing more, and the whole machine collapsed. 5 words, 1 document, and a case the state spent 19 months stacking brick by brick, folded in on itself like soaked cardboard. Judge Raymond Caldwell didn't shout. He didn't posture. He didn't have to. When a federal judge looks the government in the eye and tells them the spine of their case is a lie, volume stops being a tool and becomes a distraction. The defendant, still in that chair, still wearing the weight of 18 months of slow demolition, lifted his head. For the first time since this nightmare began, he wasn't staring at a verdict being written over his life. And at the prosecution table, you could watch the moment it hit. He was staring at the possibility of walking out. The colour draining from the prosecutor's face, not from surprise, but from recognition. Because he knew exactly what that paper proved. Witness 14 got paid, and Caldwell didn't get it from rumour or insinuation. He got it from receipts. So ask yourself, how does the government's star witness end up on somebody's payroll? It doesn't happen by accident. It happens with a meeting that shouldn't have happened, a wire transfer that shouldn't exist, and a trail someone thought was buried deep enough to never see daylight. They miscalculated. And that's what makes this stink so bad. This wasn't a clerical error. This wasn't crossed wires. This was a deliberate, calculated choice. Money moving to purchase testimony aimed at a defendant facing 25 to life. 25 years. Let that land. A man sat there watching his entire future get erased in real time, while the person positioned to help erase it was cashing checks. I've covered corruption, cover-ups, abuse of power. I've seen the usual ugliness, but this one made me physically angry because the system didn't catch it. The system didn't hunt it. The system was shielding it, until Judge Caldwell tore the mask off in public. Everyone keeps replaying the moment Caldwell dismissed the case with prejudice. We'll get there, but first, you need to understand what the prosecution did and how far it went. Because trust me, it goes deeper than people want to admit. Here's what really happened. The ruling splitting the legal world in half. April 17th, 2024, Federal Courthouse, Northern District of California. The trial of Marcus Webb had dragged into week 3. Racketeering, money laundering, conspiracy. The kind of prosecution that makes reputations and builds careers. The government threw the kitchen sink. And at the centre of it all, witness 14. Never publicly named, but presented as the guy who was there for the key meetings, their linchpin, their smoking gun, the witness who could supposedly tie Webb directly to the conspiracy. And Judge Raymond Caldwell, 22 years on the bench, former military prosecutor, known for running one of the tightest courtrooms in the district, had been watching, quiet, precise, the type who writes in a leather notebook and catches what everyone else misses. Defense attorney Sarah Chen had spent days chiseling at witness 14's credibility. Small contradictions, timeline cracks, but nothing fatal, nothing that could blow the case open until discovery. Chen's team had filed a motion weeks earlier demanding full financial disclosure for government witnesses. In federal court, that's standard. The prosecution fought it, objected, waived national security, cited ongoing investigations, invoked witness protection. Caldwell rejected every objection. And in his order, he basically warned them, your refusal to be financially transparent is a problem this court is not ignoring. So the government partially complied. They produced redacted documents meant to show witness 14 had no financial ties connected to the case. But Chen's forensic accountant noticed what they didn't. A wire transfer, $47,500, routed through a Delaware shell company. And that shell's registered agent? An LLC controlled by the lead prosecutor's former law school roommate. The money landed in witness 14's account 6 days before his first grand jury testimony. When Chen laid it out in open court, the air changed. The prosecutor objected, called it coincidence, claimed the defense was inventing a conspiracy out of noise. Caldwell asked one question: "Is the transfer real?" The prosecutor hesitated. Maybe 2 seconds. In a courtroom, 2 seconds is forever. "Your Honour, we weren't aware." "Answer the question, counsellor. Is the transfer real?" "Yes, Your Honour." Caldwell raised a hand. He didn't need the rest. He recessed court for 48 hours. People assumed he'd return with a careful ruling. Maybe exclude the witness, maybe issue a stern warning, maybe declare a mistrial. They were wrong. When court reconvened, Caldwell didn't even sit. He stood, looked straight at the prosecution table, and delivered a decision legal scholars are going to cite for years. The government's case rests on testimony from a witness who received substantial payment from entities connected to the prosecution. The court reviewed the records, the timing. The integrity of that testimony is fundamentally, irreparably compromised. He paused. Case dismissed with prejudice. That phrase matters. It means the government can never bring these charges again, ever. Marcus Webb walked out a free man. The prosecution walked out with their careers on fire. But here's what nobody expected. As Caldwell left the bench, he issued another order, sealed. Within hours, the FBI opened an internal investigation. Not into Webb, into the prosecution. The case didn't just end, it flipped. And when I tell you the fallout is still unfolding, I'm not exaggerating. Because that $47,500 wasn't the only payment. More witnesses, more transfers, more cases. Caldwell didn't just close a file, he kicked open a door nobody wanted open. If you're watching this thinking, finally, someone is saying the quiet part out loud, subscribe. I'm only getting started, and you're going to want to see where this goes. But not everyone is cheering. Within hours, the US Attorney's Office put out a statement calling Caldwell's ruling a dangerous overreach, one that elevates procedure over public safety. And their argument is simple. Marcus Webb, they say, is not innocent. Surveillance, wiretaps, documents. They insist witness 14 was only corroboration for evidence that already stood on its own. One former federal prosecutor framed it like this: the judge burned down an entire case over a financial transaction that might have a benign explanation. We don't know what the money was for. We don't know if witness 14 even understood the source. And now, critics warn, every defendant has a template. Find something suspicious, declare the whole prosecution tainted, demand dismissal. Legal Twitter detonated, hot takes everywhere. And even people who usually criticize prosecutorial overreach started asking the same uncomfortable question. Was Caldwell right that the payment was a problem? Almost certainly. But was dismissal with prejudice the right remedy? That's where the fight is. Constitutional law professor David Hines, who's testified before Congress on judicial reform, made the proportionality argument. If a witness is corrupted, you exclude the witness. You don't automatically torch the entire case. Caldwell's ruling may feel righteous, but it might create consequences nobody's ready for. So who's right? Did Caldwell deliver justice? Or did outrage at misconduct override the underlying evidence? Is Webb innocent? Or did a guilty man walk because the government crossed the line? And the deeper you dig, the messier it gets. Because this didn't appear out of thin air. Years of warning signs were there. In 2019, that same US Attorney's Office faced a sanctions motion for withholding exculpatory evidence in a drug case. The motion got denied, but the judge's opinion practically screamed, "Your behavior is approaching prosecutorial misconduct." Did they learn anything? In 2021, another case from the same office collapsed when defense attorneys discovered a key informant had been coached, not prepared, coached. That case was dismissed too, without prejudice, and the defendant later pled to lesser charges. Then in 2022, a whistleblower inside the office, a paralegal with 11 years in, filed a complaint with the DOJ Inspector General, alleging outcome-driven evidence handling. It was looked at briefly, quietly, and then shelved. Every time the system looked away, they kept going. Same prosecutors, same machine. Same demand that juries trust us, until Caldwell said no. And what makes this ruling different isn't just what he found, it's what he did with it. Most judges would have written a scathing opinion, excluded the witness, maybe ordered a mistrial. Caldwell didn't offer them a second chance. He didn't hand them a do-over. He ended it permanently and handed it to the FBI. The prosecution just didn't realize they were stepping into their own trap. And then it happened. The courtroom went beyond quiet, silent. The kind of silence where you can hear breath. Caldwell stood behind the bench, his face controlled, but his eyes told the truth. This wasn't routine. This was disgust. He said the court reviewed the defense motion in full, independently verified the financial records, and reached a conclusion. The prosecutor popped up. "Your Honor, if I may..." "You may not." Caldwell's voice was ice. "Sit down, counselor," he continued. In 22 years, he'd seen incompetence, errors, even lapses in judgment, but what he had not seen, until now, was a deliberate, documented effort to purchase testimony, manufacture evidence, and corrupt the pursuit of justice itself. He stared directly at the prosecution table. "Case dismissed with prejudice. And this court is referring the matter to the FBI Public Integrity Section for immediate investigation." 47 seconds. That's all it took for Marcus Webb to go from 25 years in federal prison to walking out the front door. But everyone missed something while they watched Webb's reaction. The lead prosecutor didn't argue, didn't object, didn't even try for an emergency appeal. He silently packed his briefcase, stood, and walked out without looking at anyone. And his second chair, shaking. Physically shaking. Because they knew something the rest of the room didn't. They knew what else was inside those financial records. That wasn't emotion. That was strategy. And that should terrify anyone who cares how justice actually works. Don't go anywhere. What I'm about to tell you expands this story far beyond one case. People in the field are calling this the most significant judicial intervention into prosecutorial misconduct in 2 decades. A former federal prosecutor, over 60 trials, now teaching at Stanford Law, put it bluntly. Caldwell just declared war on a culture of impunity. For years, prosecutors assumed violations would be handled internally. Slaps on the wrist, quiet notes in a file. And then business as usual. Caldwell proved there's another consequence. A judge can destroy your entire case if you cross the wrong line. In plain terms, prosecutors everywhere are staring at their witness lists right now and wondering what a defense team might find. Defense lawyers are already whispering the next move. Every pending case with cooperating witnesses just became a discovery battleground. Every payment, every benefit, every financial tie, innocent or not, will get subpoenaed. Motions citing Caldwell will flood federal courts nationwide. And even some retired DOJ voices are admitting the uncomfortable truth. Witness 14 probably isn't a one-off. When conviction stats shape promotions, the incentive system practically invites abuse. Caldwell didn't just expose one corrupt moment. He exposed a broken structure. The message isn't only about Marcus Webb, it's about whether federal prosecution can be trusted to police itself. And based on what we're seeing, the answer looks like no. Now here's what this means right now. Defense attorneys across the country are filing emergency motions. Hundreds of them. Any case tied to cooperating witnesses from that office is suddenly under a microscope. And the question driving everything is simple. If witness 14 got paid, who else did? Over the next 30 to 60 days, expect a wave of challenges. Most will fail. Caldwell's ruling hinged on documented proof, not vibes. But the investigations triggered by those motions, they could uncover more. If you follow federal cases, you're about to watch something rare. Prosecutors forced onto defense, explaining themselves, justifying witness relationships, proving they played fair. And here's the part nobody wants to say out loud. How many people are in prison because testimony was effectively bought? If this office paid witness 14, and if this wasn't the first time, then there may be people sitting in cells right now convicted on manufactured evidence, not technicalities, not guilty but rights violated. Potentially innocent people, destroyed because winning mattered more than truth. That's the conversation Caldwell just forced the country to have. And the Department of Justice? No answers. Not yet. Then the prosecution made it worse. 24 hours after the dismissal, the US attorney held a press conference, not to apologize, not to acknowledge wrongdoing, but to attack Caldwell. He framed it as a misunderstanding of how federal investigations operate. He called financial support for at-risk witnesses protection, not corruption, and warned the ruling puts lives in danger. Instead of owning it, they doubled down. Social media reacted exactly how you'd expect. Legal Twitter shredded the statement. Former prosecutors called it a messaging disaster. Defense attorneys were celebrating out loud. And then it turned dark. Within 48 hours, someone leaked Caldwell's home address online, posted across multiple platforms with a photo of his house. The US Marshals increased security. Caldwell's wife and adult daughter were temporarily relocated. The FBI opened a leak investigation. It's intimidation, one court security official reportedly said off the record. A message. The prosecution condemned the leak publicly, called it reprehensible, and pledged cooperation. But notice what they still haven't done. They still haven't apologized for paying witness 14. They still haven't admitted wrongdoing regarding the misconduct itself. They condemn the leak, but defend the conduct that lit the fire. And Washington? Silence. No statement from the Attorney General. None from the Deputy AG. Nothing from professional responsibility. Just silence. And security details. And now the story escalates, because where did the money come from? We know the route: shell company, transfer, recipient, but the true source remains unclear. Why fight so hard to keep financial records sealed, unless you already knew what was inside? Why not settle quietly? Why not make it disappear? Sources claim the FBI probe has expanded beyond witness 14. Subpoenas, interviews, widening circles. And here's the detail that froze my blood. The forensic accountant who uncovered the transfer has been visited twice by federal agents, not to get her statement, but to ask about her finances. That's not defense, that's offense. Caldwell reportedly told colleagues he expects aggressive pushback, and he's ready. Something is building. Powerful people don't like exposure, and when power feels threatened, it doesn't step back gracefully. When this breaks, really breaks, we'll find out how far they're willing to go. Subscribe, notifications on, because when the next names surface, when the FBI findings drop, when the next shoe falls, I'll be here. You're going to want to see what comes next. Here's where things stand now. Marcus Webb is free. Reports say he's consulting civil rights attorneys about a wrongful prosecution lawsuit, numbers being discussed in the 8 figures. The lead prosecutor has been placed on administrative leave pending investigation. The second chair resigned 3 days ago. Neither is speaking publicly. Judge Caldwell is back on the bench, docket full, acting like nothing happened, exactly what you'd expect from a 22-year veteran. But here's what isn't in the official reports. 2 other cases tied to this team have quietly had sentencing delayed. No public explanation, just postponed indefinitely. 3 incarcerated defendants have already filed motions citing Caldwell's ruling. 1 claims documentary proof of similar payments in his case. And the FBI investigation remains sealed, but 3 agents have been assigned full-time. 3 agents on one matter usually means they expect more than a dead end. The clock is ticking, and everyone involved knows it. But what keeps me up at night is the prosecution's posture. The defiance, the attacks on Caldwell, the refusal to concede anything. That confidence only makes sense if they believe they'll survive it. If they believe the system will protect them, like it always has. Maybe they're right. Maybe it gets quietly buried. Maybe people move on. But cases like this rarely end clean. There's a reason the forensic accountant is being questioned. There's a reason witnesses went silent. There's a reason Washington won't say a word. Someone is scared. And scared people make mistakes. I don't know what the FBI will find. I don't know how many names are tied to this. I don't know if Caldwell exposed the tip of an iceberg or the whole thing, but I do know this. Whatever happens next will be bigger than anyone expects. The only question is, will you be watching when it breaks? Subscribe, notifications on. Because when this story explodes again, and it will, I'll be here. Something is about to